The first annual property tax roll component you will learn about is the assessed owner. To understand what assessed owner means, you will learn about basic concepts of property law. At the end of this lesson, you will be able to identify different types of real property ownership interests and how title to real property is held. You will also be able to identify the records used to determine ownership and where to find them. The assessed owner is the owner of the taxable property on January 1. Again, property taxes are assessed to the person who is the owner as of January 1. Remember, our fiscal calendar year and timeline. Everything starts with the January 1 assessment date. To create the annual property tax roll, you will need to determine who is the owner on that date. The assessed owner is personally liable or legally responsible for paying the tax for the entire fiscal year. Let's think about the fiscal year calendar and timeline. January 1 is the date tax liability is fixed. The tax assessed as of that date is for the entire fiscal year and is the legal obligation of the owner of the property on the assessment date, January 1. The owner may pay the tax for the year in 2 or 4 installments, depending on the billing system used by the city or town. But that is for the taxpayer's convenience. The tax for a fiscal year is a single legal obligation that the assessed owner owes, even if the property is sold during the fiscal year. A purchase and sale agreement between buyer and seller is a private agreement between the parties and does not change the personal liability of the assessed owner to the city or town for the entire year's tax. However, Mass General Laws, Chapter 60, Section 3, allows the tax collector to mail the tax assessment bill to the new owner, who was the one most likely to pay it, instead of mailing the bill to the assessed owner on January 1. For land or real property, the owner of record is the owner for assessment purposes. What is a record owner? A record owner is the person who is the owner according to records of the Registry of Deeds and the Registry of Probate of the county where the real estate is located. You are considered to have knowledge of the contents of these records. An assessment to the record owner is for your administrative convenience. What does that mean? Under Massachusetts General Laws, Chapter 59, Section 11, you may rely solely on documents recorded in the Registry of Deeds and Probate to determine the owner of the real estate on January 1. If you assess the record owner on that date, your assessment is valid. You may also assess to someone who is not the record owner, but you will not have the protection of the statute. If the person assessed is not the actual owner on January 1, the assessment is invalid and, if not paid, will be uncollectible. Here is an example of a record owner. In this example, Ann sells Black Acre to Barbara and gives her a deed for the property. But Barbara did not record her deed at the Registry of Deeds for some reason. In this case, Ann is still the record owner because only the deed to Ann is recorded at the Registry of Deeds. If you assess Ann as record owner, the assessment is valid even though Barbara has title and is the actual owner. If you assess Barbara, that assessment would also be valid as she is the actual owner. The best practice, however, is to assess the record owner unless you are absolutely certain someone else is the actual owner of the property. Again, if you assess to someone who is not the record owner, your assessment may be invalid. If an assessment is invalid, the collector will not be able to legally collect the tax. Let's take a closer look at the documents that are recorded at the Registry of Deeds and Registry of Probate. Registry of Deeds records include documents that transfer interests in real estate, such as deeds, mortgages, certificates of title, and trust documents. Registry of Probate records include documents that relate to processing the estates of deceased persons and transferring property owned by deceased persons at the time of their death. In order to determine the record owner of property for assessment purposes, you need to become familiar with the ownership records at the Registry of Deeds and Registry of Probate. Under Massachusetts General Laws, Chapter 36, Section 24B, you may request in writing that the Register of Deeds furnish you with copies of information about recorded documents that affect the title to real estate in your city or town. There are also services that can provide you with recorded documents regarding property transactions within your city or town. Registry of Deeds records are also mostly available online. This is how you maintain current ownership information so that when you prepare the annual property tax roll, the information is up to date. You may also request copies of Registry of Probate records from the Register of Probate under Massachusetts General Law, Chapter 217, Section 16A. Although Registry of Probate records are not accessible online like the records of registries of deeds, some records can be accessed on the web. The website address is referenced in your handbook. The website will not give you access to the records themselves, but will tell you if a filing has been made in probate court regarding a deceased person's estate. You may be able to view what is called a probate docket, which lists the activity in the case, and it may show whether a will has been approved. The online information is a tool to assist your further inquiry into record ownership. A deed is the written legal instrument signed by the grantor or seller that transfers ownership of real estate interest from one party to another. What information is included in a deed? The name of the grantor, that is the seller, the name of the grantee, that is the buyer, and new owner, and how title is held. The date the grantor signed the deed, the date the deed was recorded, a legal description of the property conveyed, usually by referring to metes and bounds or a recorded plan. The physical area within the legal description is what should be assessed to the new owner. If there is a discrepancy in the deed between the land area stated in the deed, for example 25 acres, and the actual land area contained within the description, 25.5 acres, the grantor conveyed the 25.5 acres identified in the legal description. The signature of the grantor, the book and page number where the grantor's deed is recorded or title reference, and the book and page number where the current deed is recorded. This is all information that will help you determine the assessed owner. This shows a sample deed and where to find the grantor's name, grantee's name, property description, grantor's signature, title reference to where the deed to grantor is recorded, title reference to this deed. You may see different types of deeds. In Massachusetts, quitclaim deeds are the most common type. Quitclaim deeds transfer whatever title the grantor has and includes a guarantee the grantor has not done anything during his or her ownership to cloud the title. You will mostly see quitclaim deeds. You may also see specialized deeds. These deeds are classified by the purpose of the deed or type of grantor. One example is a sheriff's deed, which is given by a sheriff when property is sold to satisfy court judgment. Your handbook has some other examples of specialized deeds. In each case, the contents of these deeds will include the basic information required in a deed that was discussed previously, including the name of the grantor or seller, name of the grantee or buyer, and a property description. This is the information you need to know to determine the assessed owner. Another type of ownership record is called a certificate of title. It is used to transfer ownership of registered land. Massachusetts has a system of registering title to land through the land court in order to resolve title discrepancies. The land court handles legal actions relating to the title to land. It is located in Boston, but each registry has a land court section. A certificate of title and decree plan are recorded in the land court section of the registry for each property adjudicated by the land court. The certificate describes the property and lists any easements or encumbrances. The certificate of title has a certificate number and is recorded by the certificate and document number, not a book and page reference. Transfers of ownership interests in registered land require registering the transfer. If the fee simple is being conveyed, a new certificate in the name of the new owner must be issued. If another interest is being conveyed, it is registered by filing the deed or other instrument creating or transferring the interest, and that is noted on the certificate. You generally assess the person or entity who is the owner or holder of the present interest in the property. What is a present interest? If the person or entity is currently entitled to possession, use, and enjoyment of the property, the person or entity holds a present interest in the property. If the person or entity is not currently entitled to possession, use, and enjoyment of the property, and the right to possession will come into being at a future time, the person or entity holds a future interest in property. There are different types of ownership interest or estates in property. We are going to discuss the three interests that you will see most frequently and who is the owner you assess for each type. The three types are the fee simple estate, the life estate, and the leasehold estate. A fee simple estate is full ownership of real property and you assess the owner of that estate. The owner of a fee simple and his or her heirs have a present right to possession, use, and enjoyment of the property. Therefore, the duration of the fee simple estate is for an unlimited period of time, potentially infinite or forever. The owner of a fee simple may pass full ownership to someone else by deed, will, or inheritance, and may mortgage, rent, or lease the property. The fee simple is the maximum allowable property interest known in our law. If you own a fee simple, you own it all. That is, you have the full bundle of rights associated with property ownership. The next type of ownership interest is the life estate. The primary characteristic of a life estate is that it creates successive legal interests in the same property. That is, one interest follows another. The first interest in the life estate is held by the life tenant. It is a present, possessory interest for the duration of someone's lifetime. The interest that follows the life estate, the succeeding interest, is held by a remainder man. That interest is a future, remainder interest where possession does not start until sometime in the future, at the end of the life estate. The duration of a life estate is limited. It is measured by a specific person's life. A life estate may be created by deed, will, recorded lifetime lease. A life tenant can convey his or her life estate to another, but not the future rights of the remainder man. So, when a life tenant conveys his or her life estate to another, the person receives a life estate that ends when the original measuring life ends. In some cases, however, a life tenant may be given powers in addition to the life estate, such as the power to mortgage the property or convey the fee interest to another. The deed or instrument that grants the life estate must specifically grant these powers in writing. When granted, the remainder interest is subject to the power of the life tenant to exercise them. Various words can be used to create a life estate. In this example, Anne grants Black Acre to Bob, reserving a life estate to herself. Here, Anne is the owner of the fee simple, and in her deed to Bob, she reserves for herself a life estate. Anne is the life tenant. The duration of Anne's life estate is the duration of Anne's life. Bob is the remainder man. Bob does not have a present right to possession. His right to possession does not come into effect until the future event of Anne's death. Here's another example. The grantor, Anne, conveys Black Acre to Bob for his life, then to Carol. In this case, Bob is the life tenant. The duration of Bob's life estate is the life of Bob. Carol is the remainder man. Carol's right to possession of Black Acre does not take effect until Bob's death. Anne no longer owns any interest in Black Acre. She has conveyed it all away to Bob, the life tenant, and the remainder man, Carol. The third type of property interest is the leasehold. For property tax assessment purposes, the landlord or lessor, who usually owns the fee simple interest in the leased premises, is the assessed owner. Under a lease, the lessor receives rent from the lessee, who has the right to possess and use the premises for a period of time. There is one exception, however, when a lease has a term of 100 years or more, and there are at least 50 years left in the term. In that case, the lessee or tenant is treated as the owner of the fee simple estate for all purposes, including property tax assessment under estate law. The lease itself, or a notice of the lease, must be recorded at the Registry of Deeds to assess the tenant or lessee in that case. This is because assessments are to the record owner, the owner according to the records of the Registry of Deeds or probate of the county where the land is located. In all other cases, you disregard the lessee. Now we are going to discuss the different ways to own or hold title to real property. You will need to understand these concepts to determine an assessed owner or who to assess when the owner dies. The common forms of ownership are sole ownership, multiple ownership, and in trust. Sole ownership is exactly as its name suggests. The property is owned by one person or entity. If you own property in your sole name, you own it all by yourself. Taxes are assessed to the sole owner. Multiple ownership is exactly as its name suggests. Title held by two or more persons or entities. This is also referred to as concurrent estate because two or more persons or entities have an interest in the same property at the same time. When there are multiple owners of the property, you must assess in the full name of at least one of the owners of record. You can add the other co-owners as your billing system allows. Why can one owner be assessed the entire tax? Because co-owners are jointly and severally liable for the tax. This means that each one is individually responsible for the whole of the tax. The three types of multiple ownership you will see are the tenancy in common, the joint tenancy, and the tenancy by the entirety. Let's look at each type in more detail. In a tenancy in common, each co-tenant or co-owner has an undivided interest in the whole property. For example, if a co-tenant has a one-half interest, the tenant doesn't own a particular one-half of the property. The tenant owns a one-half interest in the whole property. A conveyance to two or more owners is a tenancy in common unless there is a clear, express intention stated in the deed or other instrument to create a tenancy with survivorship rights. In a tenancy in common, the ownership interests can be unequal. For example, one person can own one-half interest and the others can own one-quarter each. However, each owner still has an equal right to possession, use, and enjoyment of the entire property. The person's share or amount of interest is determined by the instrument that grants the interest, for example, a deed or will. In a tenancy in common, each co-tenant may acquire his or her interest at different times and may convey the interest to another person. If a tenant in common dies, his or her interest does not go to the other surviving co-tenants in common. The interest of a deceased co-tenant in common will pass to the deceased co-tenant's heirs or to the deceased co-tenant's devisees, if the co-tenant had a will. There is no right of survivorship among co-tenants in a tenancy in common. In this example, Alex, Bob, and Carl received a deed of Black Acre. In a tenancy in common, the co-tenants can have different shares. Here, Alex has one-half ownership share, and Bob and Carl have one-quarter each. All three can possess any or all of Black Acre. This is so even though Alex has a greater share in Black Acre. They are tenants in common. In this example, Alex, Bob, and Carl acquired their interests in two separate deeds. Bob and Carl received their one-quarter each interest in one deed, and Alex received his one-half share in a separate deed. Again, since they have different ownership shares, they own Black Acre as tenants in common, but all three can possess and use any or all of Black Acre. In this example, Mom and Dad did not specify the shares, and therefore, each of the new co-owners are presumed to be equal shares. In addition, the deed does not include words needed to create a joint tenancy, like joint tenants or joint tenancy, or right of survivorship. So here, Bob, Carl, and Alex are tenants in common with a one-third share each. Now we are going to talk about a second form of multiple ownership, the joint tenancy. A joint tenancy is a shared ownership with two distinguishing features. First, there is a right of survivorship, and second, it has what are called the four unities: unity of interest, possession, time, and title. The first distinguishing feature of a joint tenancy is the right of survivorship. When a joint tenant dies, his or her share passes to the surviving joint owners by operation of law. No deed or other action is required. It is automatic. Nothing passes to the heirs or devisees of a deceased joint tenant. The last surviving joint tenant becomes the sole owner of the property. The other distinguishing feature of a joint tenancy is that it has the four unities. The four unities is a legal term. The first two unities are unity of interest and possession. Each joint tenant must have an equal undivided interest and right to possess the whole property. If there are two co-tenants in a joint tenancy, each must have one half. If there are three co-tenants, they each must have one-third. This is unlike the shares of tenants in common, which may be different. There must also be unity of time and title. That means each joint tenant has acquired his or her interest in the property at the same time and by the same title or instrument, whether it be a deed or will. Joint tenants can convey their own interests. However, a conveyance by a joint tenant creates a tenancy in common between the new owner and the other co-tenants, who remain joint tenants. This is because the conveyance destroys the unity of time and title required for a joint tenancy with the new owner. The new owner obtains his or her interest at a different time and by a different deed. There is still unity of possession and interest in that all co-owners still have equal rights to possession and own the same share. But because there is no unity of time and title with the new owner, there is no joint tenancy. In this example, Mom and Dad conveyed Blackacre to their 3 sons. When the amount of the shares are not specified, as in this deed, the law deems them to be equal shares. Because the words joint tenants are used in the deed, there is an express or written intent in the deed to create a joint tenancy. Therefore, they each have a 1/3 interest in Blackacre. They all have an equal right to use and possess all of Blackacre, not just a particular section or piece of it. So they have unity of interest and possession. In addition, each joint owner acquired title at the same time and by the same deed. They also have unity of time and title and hold title as joint tenants. In this example, Alex, Bob, and Carl own Blackacre as joint tenants. Each have an equal undivided 1/3 interest with an equal right to use and possess all of Blackacre. Alex sells his undivided 1/3 interest to his friend Dave. Dave holds that interest as a tenant in common with Bob and Carl. Dave is not a joint tenant with Bob and Carl because he does not have unity of time and title with them. He took title at a different time by a different deed. The conveyance to Dave does not change how Bob and Carl hold their undivided 1/3 interests in Blackacre. They are still joint tenants with each other. There is also still unity of possession and interest in that Bob, Carl, and Dave all still own the same 1/3 share and can use and possess all of Blackacre. Another form of multiple ownership that you will see is called the tenancy by the entirety. The key characteristics of a tenancy by the entirety are that only a married couple can hold title by a tenancy by the entirety, and there is an indestructible right of survivorship during the marriage. This is different from a joint tenancy where the right of survivorship can be destroyed by a conveyance of the joint tenant's interests to another. Since a tenancy by the entirety can only be held by a married couple, the couple must be married at the time of the conveyance. If an unmarried couple later gets married, the tenancy is not transformed into a tenancy by the entirety. In addition, if a married couple later divorces, the divorce ends the tenancy by the entirety and the former spouses become tenants in common. The deed has to say the couple is taking title by tenancy by the entirety, as the couple could choose to take title as joint tenants or tenants in common. With a tenancy by the entirety, there is an indestructible right of survivorship during the marriage. That means that neither spouse can alone defeat the right of the surviving spouse to the entire property. Both spouses must join in a deed to convey the entire property and end the right of the survivor to it. Now that we've reviewed sole and multiple ownership of real property and looked at some examples, let's discuss the third form of ownership, a trust. In a trust, one party holds legal title to property to use it for the benefit of another. The distinguishing characteristic of a trust is that it creates separate but simultaneous and concurrent interests in the same property. Ownership is divided into 2 interests that exist at the same time, the legal interest and the beneficial interest. The legal interest is held by a trustee or trustees, and the beneficial interest is held by a beneficiary or beneficiaries. In a trust, the trustee holding legal title to trust property has a fiduciary obligation to the beneficiary to use the property for his or her benefit. The word fiduciary is derived from Roman law and means one who has a duty to act for another. You assess taxes to the trustee who holds legal title to trust property. A trustee who also has a sufficient beneficial interest in the property under the trust is also an owner for purposes of qualifying for a property tax exemption. You'll learn about exemptions in Module 7 of this training. In a trust, the property subject to the trust is called the trust corpus or trust estate. Trust property can be real estate, tangible personal property, that is, jewelry or works of art, or intangible personal property, that is, cash, stocks, and bonds. A trust may be created by will, deed, or declaration of trust. Who are the parties of a trust? The settlor is the person who creates the trust. If the trust is created by will, the person is also referred to as the testator. The trustee is the person who holds legal title to trust property in a fiduciary capacity for the benefit of the beneficiary. The beneficiary is the person for whose benefit the trust was created and is the person entitled to benefit from the trust assets, including rents, profits, sales proceeds, or other income. There are different types of trusts. Trusts created by a person during his lifetime are inter vivos trusts. Inter vivos means while living. Trusts that are created by will are testamentary trusts. Trusts are created for a number of different reasons, including for estate planning purposes and to avoid probate, to protect property from a beneficiary's creditors. These are sometimes called spendthrift trusts, and for the ease of transferring title, and for the young, disabled, or elderly who need someone else to manage their property and take care of their needs. Trusts are often described by the assets that make up the trust corpus or the relationship of the parties of the trust. Those trusts are exactly what their names imply. Realty trusts hold real estate, and family trusts describe the relationship of the trustees and the beneficiaries. Another type is a nominee trust, where one or more persons declare they hold the title to the real estate as trustees for undisclosed beneficiaries. The trustees have no power to deal with the property except as directed by the beneficiaries. The relationship is more in the nature of a principal and agent relationship. The arrangement allows for anonymity of the beneficiaries and ease of transfer of the beneficial interests, often avoiding title issues for beneficiaries. Regardless of the type of trust, you assess property taxes on property subject to a trust to the trustee of record as the holder of legal title to the property. Records found in the Registry of Deeds related to trusts include trust instruments, amendments to the trust instrument, and documents related to trustee changes. For inter vivos trusts, a declaration of trust or certificate of trust is recorded at the Registry of Deeds. A declaration of trust is the instrument a settlor uses to create an inter vivos trust. It identifies the trustee. The beneficiaries may be identified, but more often they are identified in a schedule, which may not be recorded. Under Mass General Laws, Chapter 184, Section 35, a certificate of trust that identifies the trustee and name of the trust can be filed at the Registry of Deeds instead of the declaration. Most inter vivos trusts can be revoked and amended, so amendments may be recorded at the Registry of Deeds. One of the advantages of holding title in the form of a trust is that title to and record ownership of trust assets can change without a deed, simply by changing the trustee, the holder of the legal title of the trust property. This is done through recording the following documents: an amendment of the trust naming a new trustee, documents showing the death, resignation of the trustee, the appointment of a new trustee and acceptance of the appointment by the new trustee, or a new certificate of trust naming a new trustee. By changing the trustee of record, the record ownership of the trust property changes. We are now going to examine how you handle assessments after a record owner dies. Who do you assess when the record owner dies? You continue to assess the record owner until the owner's death is of record. What is a death of record? A death of record is when a death certificate has been recorded at the Registry of Deeds, or a petition for probate or administration is filed at the Registry of Probate. Let's look at an example. Here, the last deed for the Green Acre property was recorded in 1978 when Dan sold it to his friend Ed. According to the town clerk, Ed died in 2005, but there is no record of his death in the county records at the present time. There is no record of a death certificate at the Registry of Deeds or a probate filing for Ed's estate in the Registry of Probate. So here, Ed is still the owner of record, even though Ed has died. Therefore, an assessment to Ed, the record owner, is valid. What happens when there is a death of a life tenant? Who do you assess? As you learned earlier, a life tenancy divides legal title by time and creates successive interests in property. The life tenant is the holder of a present possessory interest in the property for his lifetime and is assessed owner for property tax purposes. The remainder man holds a future remainder interest. The remainder man's right to possession is delayed until the death of the life tenant. Upon a death of record of the life tenant, you assess property taxes to the remainder man because remainder interest has become a present possessory interest on death of life tenant. Who do you assess when a joint tenant or a tenant by the entirety dies? Recall that in a joint tenancy and tenancy by the entirety, there is a right of survivorship. The interest of a joint tenant or tenant by the entirety who dies passes automatically by law to the surviving joint tenants or tenant by the entirety. When there is a death of record of joint tenant or tenant by entirety, you assess property taxes to the surviving joint tenants or tenant by the entirety. Again, a death of record for the deceased owner occurs when a death certificate is recorded in the Registry of Deeds or a petition for probate or administration is filed in probate court. Who is assessed when the trustee of a trust dies? As you learned earlier, in a trust, title to and record ownership of trust assets can change without a deed when an amendment of trust is recorded naming a new trustee, or the trustee dies or resigns and documents are recorded at the Registry of Deeds showing the resignation of death of the trustee and the appointment and acceptance of new trustee, or when a certificate of trust is recorded naming a new trustee. When the appropriate trust documents are recorded in the Registry of Deeds, you assess taxes to the new trustee of record named in those documents. Who is assessed when there is a death of record of a sole owner or a tenant in common? Recall that when a sole owner dies, the owner's interest passes to the deceased owner's heirs or devisees under the owner's will. Similarly, the interest of a deceased tenant in common passes to that tenant in common's heirs or devisees under a will. There is no right of survivorship in a tenancy in common. We will now look at how you determine the assessed owner when the death of a sole owner or tenant in common is of record. When a sole owner or tenant in common dies, the person's interest in real estate is passed to others by a will or the laws of intestate succession. These matters are determined by the probate court. The probate court is a specialized court that handles the disposition or transfer of the real and personal assets of people when they die. In order to know to whom to assess the property taxes when there is a death of record of a sole owner or tenant in common, you will need to be familiar with basic probate proceedings and records. What is a will? A will is a written document where a person chooses the person to receive his or her property after death. It is a disposition by choice. Persons who are given property under a will are known as devisees. The decedent who wrote the will is the testator or testatrix. A will has no effect until a testator or testatrix dies and the will is approved by the probate court. A person who dies without a will dies intestate, which just means without a will. In that case, the disposition of the person's property is by the laws of intestate succession. Persons who take property by intestate succession are called heirs. Your handbook describes the basic rules for intestate succession and who are heirs. When a sole owner or tenant in common has died, and there is a death of record, but the probate court has not yet named the heirs or devisees, you must assess taxes to the heirs or devisees of the decedent, generally, not by name. Under estate law, you do not assess taxes to the estate of the decedent in this case. If you do, the assessment is invalid. You assess taxes to the estate of the decedent only if the will is being contested and the validity of the will has not yet been decided by the probate court. Again, the assessment of the tax in this situation is governed by estate law. Once probate records show the court approved the will or the settlement of the intestate estate of the deceased sole owner or tenant in common, the devisees or heirs will be identified in the court documents. You now assess the taxes to the devisees or heirs identified by name in the probate court records. Note that title to a decedent's real property vests in the devisees named in the will, or the heirs at law, as of the date of death. This is a very important rule. Once the will is approved by the probate court, or if the decedent did not have a will, once the petition for administration of the estate is allowed and heirs are established, the ownership of the real estate by the devisees or the heirs relates back to the date of the decedent's death. This is because the law does not favor gaps in real property ownership. The title goes from the deceased owner to the heir or devisee without gaps. Therefore, to ensure a valid assessment when a sole owner or tenant in common dies before the January 1 assessment date, you must review the probate records up to the time you make the actual property tax commitment for the year to determine, number one, if there is a death of record, or number two, whether the person's devisee or heirs have been named in probate records. In this example, Ellen, who was sole owner of Green Acre, died on September 15, and there is a probate filing in December, making her death as of record. Therefore, as of the January 1 assessment date, it is a matter of record that Ellen is not the record owner, but we don't know who Ellen's successor is. In April, the probate court approves Ellen's will and Fred is established as the devisee of the property. That means Fred is the record owner of Green Acre as of September 15 in the year before January 1 because his ownership relates back to Ellen's date of death. Because Fred's ownership is effective September 15 before the January 1 assessment date, Fred is the record owner you assessed for the following fiscal year. This is why you need to check the probate records for sole owners or tenants in common who died before the January 1 assessment date before finalizing the annual property tax commitment for the fiscal year. In this example, the probate court has not yet finished processing Ellen's estate by the time of the annual property tax commitment is issued. You can't assess the taxes to Ellen because a death of record has been filed for Ellen before the January 1 assessment date. Who do you assess? In this case, you assess taxes for the devisees or heirs of Ellen. Let's review the key concepts discussed in this lesson about assessed owners. First, property taxes for a fiscal year are assessed to the owner of the property on the January 1st before the beginning of that year. For real property, the owner found in the records of the Registry of Deeds and probate is assessed. Assessors are presumed to have knowledge of those records. Second, when more than one person or entity owns the property, assessors must assess taxes to at least one of the co-owners. They may also assess any or all of the other owners as well. They must know the type of multiple ownership in the event one of the co-owners conveys his or her interest or dies, as the type governs who and how the interest is then owned. Third, a trust is a form of ownership that divides the legal and beneficial interest in a property. The trustee who holds legal title to the trust property is the owner for property tax assessment purposes. Ownership of trust assets can be changed by changing the trustee. No deed is required. And fourth, who succeeds to the ownership interest of an assessed owner who dies depends on the interest. The interest of a joint tenant or tenant by the entirety passes to the surviving co-owner or spouse. The interest of a sole owner or tenant in common passes to the devisee named in the decedent's will, or heirs at law if there is no will.